Okay, let's move, Mr. Fuad. Today's session on point of the public interest litigation. Whether this term is used largely, not. That should be focused from the side of law doctor to you. And Anika, please write down. Today's session is very much interesting to understand that and to comprehend that what is public interest litigation and what are the main proponents or the expounders who venture to define it, and what are the landmark decisions in the world. That should be focused from the side of law doctor to you. Okay, let's start. There's no fucking approach in terms of the public interest litigation. So how can we actually discuss in this regard? First of all, we have to focus in terms of the landmark decision in a country, Kazi Mokhlisur Rahman versus Bangladesh. This is well known to you, that the Berubari case, oh my God, that the third amendment case law in our draft constitution. Mr. Fuad, please write down what I actually delivered to you, as you are the genius in our society in terms of Medhana Kota. So the public interest litigation is the core point. Let's move and write down. Public interest litigation can be defined from the term itself. It means a litigation. Well, you all know in this regard. It means a litigations which filed by person in the interest of the public at large. Therefore, public interest litigation means a litigation for the protection of public interest. But unfortunately, we have no, please write down. Unfortunately, we have no knowledge at all how to define that very phrase. Of course, this is the phrase. And what type of phrase is it? We have already focused and we have already discussed in several times that the adjective and the noun which denotes that noun phrase is grammatical perspective. So it means a litigation. And public interest litigation means a litigation for the protection of public interest. So this is the system required. So what type of public interest? We have no knowledge at all, but you have already, as you are the student of University of DHAKA. And as you are the students of Lincoln, what exactly in terms of this situational case? Oh my God, we have no what exactly the billing knowledge. That is very much helpful for you. Well, so no matter, just here and write down, and you have to actually find out the core point of that. What is public interest litigation? This power has been given to the public by the court. Of course, this is the core point. This power has been given to the public by the court to judicial activism. Oh my God. So what is judicial activism? Already you have studied from the side of the class Shufun Surf, the renowned teacher in Dhaka University and the renowned teacher in our University of Rajshahi, Johid Sir, Professor Johid Sir prescribed in this regard. And not only that, Shahidar Parvez is one of the genius law teacher in your country. Already you have studied in this regard. So I'm a pretty teacher in terms of law, in the field of law. So I'm not able to discuss in such way and truthfully. Just I'm trying at my level best to discuss in this regard. Of course, I have no knowledge of law. According to Mr. Shahriar Forbes, I have knowledge in law. So there is a far distinction between the two. This power has been given to the public by the court. Please write down. Through the judicial activism. So this is well known to this noun phrase, judicial activism, adjective plus noun, that prescribes that from the side of the jurisprudence. Oh my God, jurisprudence. This is the power from the side of the judges. So there is the option to uphold my voice to you that the judgment law. But sometimes we have already focused in terms of there is no law which is made by the law. They just declare the laws according to jurisprudence. However, for this litigation, what exactly the litigant has to satisfy the court that he has initiated the litigation not for his own personal interest, rather for the interest of the public at large. Oh my God. For example, this is landmark decision, you know very well, Dr. Muhyiddin Farooqi versus Bangladesh, 49 DLR Appellate Division, WAF is number. So, the denotes that the Tangail, and not only that, Hazaribagh, oh my God, the pollution in terms of the tannery, oh my God. Public interest litigation refers to such of activist jurisprudence that allows a person without being personally aggrieved to pursue the court for a public reason for appropriate remedy. In Bangladesh, public interest litigation is a post-democratic or post-1991 phenomenon and its emergence must level but was largely, oh my God, I don't know. But if you have any idea, please share with me on the online dunya, and you can easily phone me over telephone, no media. But this is the what exactly the broken mobile phone. You have the opportunity to call me. So, to make it lucid, public interest litigation refers to such kind of activist jurisprudence that allows a person without being remedy. In Bangladesh, public interest litigation is the first democratic or first 1991 maybe phenomenon at its emergence or must level but with largely up to public interest litigation in Bangladesh is Article 102, oh my God, and Article 44, oh my God, 44 of the Constitution of People's Republic of Bangladesh. As we have gained this constitution, this is totally the wrapped constitution. There is no doubt in this respect. Public interest litigation in Bangladesh has not achieved the expected success due to lack of fine tuning process and the lack of expected judicial activism. Furthermore, oh my God, non-enforceable, a fundamental principle of state policy in the constitution is also bar in respect of the smooth functioning of the public interest litigation. In Bangladesh, public interest litigation can be used as a tool for social transformation, and thus it has a long way to go in future. So there is an option, Kobi Ashbi. So there is an option, Kobi Ashbi. So this is the systematic way in terms of using public interest litigation. So our keywords in terms of public interest litigation, constitutional law, and judicial activism in Bangladesh. So how far it is true and how it can be lucid and transparent in nature. That should be focused by us. Oh my God. So no one is watching this video. So this is very much shampoo the whole nation. No one is watching this video as we are lag behind, as we are ignorant people in our country and seeing this approaching power from the wrapped constitutions. There is no option to understand and comprehend that. So only 2 persons are watching this video with me. So now the prelude or the preface or the introduction in this regard. What is actually the historical background? Or the history is central progressing moment from the side of public interest litigation. Well, you all know Anglo-Saxon system of jurisprudence. Have you heard the name? Of course, you have heard the name. Please, Kobe, please write down. Just the mental pressure from the side of Michel Foucault and Lakashar. And that's why this is the power. Exercising power, I have to focus in such way. So someone imagine that from the side of bringing the knowledge of Einstein, imagination is more important than knowledge. So Mr. Kobe, please write down what I actually deliver to you. Law is not a very difficult subject. Just you have to find out what is the core point of it and what is the background of public interest litigation and how can this, what exactly the concept is being practiced in our subcontinent and USA. This is the USA is the first country who is actually uphold, who uses this term public interest litigation. But this is not the name in such way. They are calling this name, this country prescribes the public interest law, not public interest litigation. It's interchangeably used in Indian subcontinent. Well, you have all know Anglo-Saxon system of jurisprudence is the base of court system of the People's Republic of Bangladesh. Whether yes or not? Of course, yes. Of course, yes. There is no doubt in this regard. So all laws are bested from the side of British. Oh my God. So under the system, a person having sufficient interest, a locus standi. What exactly the meaning of locus standi? That is the Latin term. The meaning of this term is to, oh my God, what an approach. Ripon, Mr. Ripon. I'm in live class, my dear. So I will talk to you later after finishing this live video on the online dunya. Mr. Ripon, please. So this is the hampering system from the side of Ripon, sir. So this is the systematic way. Well, just write down and you have to find out what is the thematic approach from the side of public interest litigation, or which is interchangeably used is the public interest law in USA. Well, so we have to focus in this way. Having appropriate jurisdiction to try the suit for appropriate remedy. Theory of laissez-faire. You have already heard the laissez-faire is the base of this strict rule of locus standi. So what is the meaning of the Latin term that the phrase locus standi? So locus standi means the right itself. Oh my God. The Dr. Muhyiddin Farooqi press cuffs Muhyiddin Farooqi versus Bangladesh. This is the 49-day appellate division page number maybe one that press cuff that's whose heart bleeds, and in tracking this approaching power in this case that can be whose heart bleeds. Oh my God. So under this theory, the state has a little to concern about the welfare of the citizen of the state. Rather, its main function is to maintain internal rule and order and to defend the state for external aggregation. However, in a welfare state, government should be always ready to protect the rights of citizens. Therefore, if there is any infringement of any right of a person or group of persons, then the infringement, oh my God. But the advocate from the side under the voluntary, the prescribes that's the public interest litigation in terms of the fundamental rights violation. Oh my God. So those are the advocates under the voluntary. They prescribes that the public interest litigations may be sought from the side of the violation or the infringement of fundamental rights. This is totally erroneous decision. Oh my God. But they have no notice at all. However, if there is an infringement of any right, what exactly the meaning of any right? Whether this is the fundamental right? No. Any right means the legal rights, of course, or the fundamental rights, or the human rights, and rights of any person or group of persons, then that the infringement shall come under the review of judicial consideration by the victim himself or by a public spirited person. Public spirited person, you have all know in this regard that the Dr. Muhyiddin Farooqi. Have you heard the name? The learned advocate from the side of the Supreme Court. This is the concept of public interest litigation, that any infringement of right can be challenged by a person who is not directly connected with this matter. Oh my God. So this is the proposed approach, or the liberal approach from the side of Dr. Muhyiddin Farooqi versus Bangladesh and Qazi Mokhlisur Rahman versus Bangladesh. You know, this is the Berubari case. Well done to you. Oh my God. So this is very much difficult to understand what actually the origin. Yes, there is origin, there is a historic background. You have already the historic background. I have also, me too. Oh my God. But there is an origin or the background. What exactly the historical background of public interest litigation? The American concept of public interest litigation and the class actions of 1960s are the initial inspiration of public interest litigation. Kobi, please. You have already heard the name of the very much case law Brown versus Board of Educations. You know, the famous renowned teacher of University of DHAKA. This is Shufun sir, Mr. Shufun sir, Professor Shufun sir prescribed in this regard. The American concept public interest litigation and the class actions of 1960 are the initial inspiration of the public interest litigation. What exactly the kind of litigation is called the public interest law in the USA? Well, this is the core point. Mr. Kovic, please. Angela, please. Just what I actually delivered to you, that should be written down, and that should be focused by your memory or the central processing unit. Then you can cut a good figure in future life. What is actually public interest litigation? So the USA, this is the public interest law, but in Indian subcontinent, this is called the public interest litigation in the Indian subcontinent. The USA is the pioneer in the path of public interest litigation, which influenced some public interest litigation activists worldwide to work for public interest litigation in the 1960s and 1970s. Oh my God! The pioneer US case in the field of the emergence of public interest litigation is Brown versus Board of Education. So what is the definition of public interest litigation? To know someone, and several times that the Fiber Board asks, will ask a question, that the common question is that what exactly the introducing power? Just introduce yourself. So there is an option to introduce in tracking this definition of public interest litigation. Well, you all know public interest litigation can be defined from the term itself. It means a litigation which is filed for a person in the interest of the public at large. However, public interest is defined by Stroud's, Judicial Dictionary, as a matter of public or general interest. Doesn't mean that which is interesting as gratifying curiosity or a love for information or amusement, but that in which the class of a community have a pecuniary interest or some interest by which their legal rights or liabilities are affected. So the advocates in our country, those who are the advocates under the penalty, they prescribe that there is no option to public interest litigation in terms of the who's and whats. So this is the laughing approach. So this is the laughing approach. Public interest litigation is defined by Bhagwati Justice in the case of People's Union of Democratic Rights versus Union. This is the landmark decision you have all know in this regard of India, as public interest litigation is essentially cooperative effort on the part of the petitioner, the state, or the public authority and the code to secure observance of the constitutional or legal rights, benefits and privileges conferred upon the vulnerable section of the community, and to restore social justice to them. Moreover, Kirbal justice in the case of People's Union of Democratic Rights versus Ministry of Home Affairs. This is another landmark decision from the side of US. This is the Indian case law. Said, as I understand the phrase public interest litigation, it means nothing more than what it states, namely it is a litigation in the interest of the public. Public interest litigation is not that type of litigation which is meant to satisfy the curiosity of the people, but it is a litigation which is instead with a desire that the court would be able to give effect to the rule or section of the society. So what is the meaning of section of the society? They have no idea. Those who are the advocates under the penalty. The prescribed that's the at last. They have already functioned. They have already started in terms of at last. This is the idiomatic expression. But they have no, have no knowledge at all section of the society. So what the section of the society? Public interest litigation is known to public interest law in the USA. This is totally known to you. American Bar Association defines public interest litigation as a legal service provided without fee or at a substantial reduced fees which falls into one more of the following areas. Property law. Well, you are the advocate of under the banana tree. Number one is property law, or the civil rights law, public rights law, charitable organization representation, administration of justice. Oh my God. So those are the areas through which on this aspect, on this point, public interest litigation is being practiced. in the whole world, not in Bangladesh, in India, in the USA, Canada, oh my God, China, Australia, in every country, they have already practiced in such a way. Therefore, public interest litigation means a litigation for the protection of public interest. This power has been given to the public by the code through judicial activism. Again, please, judicial activism. What is judicial activism? So there is a term or the phrase, Mr. Kobe, please. As you are the students of the University of DHAKA, you have to very cautiously follow the instruction of mine until or unless it is impossible to comprehend the laws. Okay. Again, please. However, for this litigation, so what exactly the however perspective has come into force here? So the judicial activism, what is judicial activism? From the side of jurisprudence, you know, those who have jurisprudential knowledge at all, that the science of law, this is vague idea, science of law, but this is the principle which is applicable for the whole world. This is jurisprudence. Of course, according to Mr. Shofun, sir. Well, so judicial activism, you know, this is the, by the name already, this is on the kata or the what exact the paper-based made. This is not being practiced in our country at all. Those who are the party in power, those are the politicians, they are practicing dirty politics, and so they don't actually give the opportunity to exercise judicial activism in our country, and that's why the wrapped constitution is the outcome in our country. Well, however, for this litigation, the litigant has to satisfy the court that has initiated the litigation not for his own personal interest, rather than the what exactly initiate the litigation, what exactly the public at large. This is the what exactly this is the general aspect or the general approach from the side of that. But most of the advocates in our country, the practices, they are practicing. Of course, this is the core point in terms of at large. This is the idiomatic expression, but they have no knowledge at all. Any infringement of any rights, they have no idea in this regard, and that's why they are the greatest critic in the world to criticize. They have already focused in terms of that. So no matter how I so ever Ria is calling me, but this is high time we discuss in terms of public interest litigation. Miss Ria, please, this is not erroneously discussed. So public interest litigation refers to such kind of activist jurisprudence that allows a person without being personally active to pursue the court for the public reason for appropriate remedy. In this regard, the militant case of Movement Bench Ismail versus, this is the difficult case law. We don't go through this case law. Well, let's start in terms of public interest litigation in Bangladesh. In Bangladesh, public interest litigation is a post-democratic or post-1991 phenomenon, and its emergence or mass level birth was largely influenced by the political chance. That the abrupt political chance will actually show you this is the fucking approach from the side of public interest litigation. Oh my God. So this is not the hyperbolic or the what exactly antithesis or paradoxical approach. The reason behind this delayed implementation of public interest litigation in Bangladesh are the unwillingness of judges to break from colonial legal thinking and the unwillingness of broad interpretation of constitutional textualism. So this is the lacking, and we are lag behind. Our administration of justice crying for far too lag. So this is totally from the PN Duda versus P. Shiv Shankar and others. This is all Indian report of 1988 Supreme Court. So the case of Kazim Mokhlisur Rahman versus Bangladesh, the very case you all know that in 1974 was an early decision of Bangladesh Supreme Court, which had a strong public interest litigation flavor and was very close in establishing a judicial review in public interest. Oh my God, this is the first case law and the renowned case law to exercise the public interest litigation in terms of judicial activism or the judicial review. Oh my God. So this is the first time The Qazi Mukhlis Rahman versus Bangladesh. This is volunteer, very body case law. So no one is watching this video. I'm here. Yes, you are the genius, and that's why you are there. And you are here, and online dunya, and that's why you have to actually follow the instruction of law doctor. So no one is discussing in such a way in our country. Just imagine, and imagination is more important than knowledge, according to Mr. Einstein, Mr. Abjal. So no lecture preview will actually satisfy you like the public interest litigation. Okay, so the case of Qazi Mukhlis Rahman versus Bangladesh is the first time this is the landmark decision in terms of public interest litigation. However, in 1991, the Bangladesh Supreme Court rejected the possibility of public interest litigation in the case of Bangladesh Sangbadpatro Porishod versus Bangladesh. Oh my gosh, this is the Sangbadpatro case law. It's unlike Indian constitution, Bangladesh constitutions, oh my god, this is very vague idea. Required person agreed test for constitutional remedy under Article 102 of the constitution. This is the wrapped constitution. The Sangbadpatro case starts, in our constitution, the Federation is seeking enforcement of fundamental law must be person agreed. The emergence in India of pro bono public litigation has been facilitated by the absence of the constitutional provision as to who can apply for a writ petition. The public interest litigation owned its jurisprudential battle and was finally accepted in 1996 by the case of Dr. Muhyiddin Farooqi versus Bangladesh. Oh my god. And this is one and two 520 case. Oh my god. You have all know in this regard that the 520 case. In this case, an organization, namely Bangladesh Environmental Lawyers Association BELA, was granted local assistance to challenge an ongoing flood control project. However, in this case, Justice Kamal made a much awaited statement when a public injury or public wrong or an infraction of a fundamental right. Please. Okay. Quickly, this is the word exactly the, oh my god, Tanzi. This is the motion from the side of law doctor Chiu. This is the Tanzi. So this is very hampering system from the side of the law doctor Chiu. In this case, the organization, namely Bangladesh Environmental Lawyers Association BELA, was granted local assistance to challenge an ongoing flood control project in Tangai. Moreover, in this case, Justice Kamal made a massive statement when a public injury or public wrong or an infraction of a fundamental right affected when intermediate number of people is involved. Any member of the public, being a citizen or an indigenous association, has a right to invoke the codes. But exactly the code's jurisdiction invokes the invoking media. This is the liberal approach or the progressive approach in terms of the what exactly the interpretation of statutes. Oh my god, interpretation of laws or the statutes. So the public interest litigation, what exactly the public interest litigation shall be filed in public interest. Therefore, in ideal public interest litigation, 3 states are involved. Public interest shall be number 1. So number 1, please, let's have a look and write down, please. Public interest shall be given priority over special interest. Number 1. And then number 2, the judge shall decide the public interest by exercising his or her discretionary power. Oh my god, this is the discretionary power. The judge shall exercise his or her discretionary power judiciously as opposed to whimsically or arbitrarily. Oh my god, this is the closing system which is be adjusted or added this situation whimsically that cannot be used, or the arbitrarily that cannot be practiced. The constitutional backing of public interest litigation, and when the public interest can be filed, on what grounds that can be filed. Number 1, public interest litigation is filed for the benefit of the society as a whole or a segment of the society. And so here is the core point. But most of the advocates who are living under the banana tree, they prescribe that the whole or at large. This is the phrase, but they have no knowledge that a segment of the society. So who are the segment of the society? You know, for example, the drawing example using barrister is not applicable in our country. So the segment of the society, those who are the other advocates in our country, they're the practicing laws, they are the segment of the society. So there is an option to initiate a writ petition before the High Court division. Oh my god, but this is not the new idea from the side of law doctor. Therefore, for public interest litigation, there must be a public cause as opposed to a private cause. However, public cause includes several situations where the inter-public or inter-community is affected by the matter in question, where a vulnerable segment of the society is involved by the matter in question, but one or more individuals are affected by the matter in question, but its nature is so gross, serious that the conscience of the whole community is shocked. For a public interest litigation, an individual or organization may approach the court in good faith. This includes suo motu, on his own motion, activity of the judges because the judge himself is a conscious citizen of the state. In public interest litigation, the court follows the non-adversarial system of litigation as opposed to the adversarial system of litigation. As we are living in the adversarial system of litigation, as we are living in hybrid country like this, what exactly this is common law country or the civil law at all, and not customary law, Sharia law, all are what can say like this, the Joga Kisuri in our existing society, in our existing state. So courts activism and flexibility in public interest litigation. What are the flexibility? So number one is the flexibility, the liberal interpretation of the first and exit test for ensuring local system rights of the petition, which is found. You have all know this is that Dr. Mahiddin Farooqi versus Bangladesh 49 DLR Appellate Division, page number 1. Maybe this is the page number. Here is quite clear to whose heart bleeds. Oh my God. Whose heart bleeds, according to Professor Johit sir from the side of University of Russia. If heart. Oh my God. Oh my God. So number two, during the process of adjudication, the court shall ignore the procedural rigidity and formalities like the adversarial system of the administration of justice, which will be cabined from the what exactly the PN Duda versus P. Shiv Shankar and others. It's the 19. What exactly the All Indian Report in 1988 Supreme Court. This is the Indian caste law. Our justice system cries far too long. And number three, in providing relief, the court shall go beyond the traditional techniques and grant innovative and appropriate remedies. This is the innovation. So innovation will be practiced by the judges. So there is an option to exercise, that's the judicial activism. Oh my God. Boundary of public interest litigation. What are the boundaries? Number one is 2, 3, and what exactly the boundaries value of public interest litigation? So remedies in public interest litigation. Why from this remedy that should be focused in later? So today's number. Bye bye.